All right, so top of the day to you, man. Today we are going to watch an updated video on a gun law update by the USCCA. We are just kind of gonna do some comment here real quick. The original link is in the video. I mean, in the
Today, we're going to be talking about a decision that just came out of a three-judge panel, the Ninth Circuit Court of Appeals. The case is called USA v. Duarte, and it stands for the proposition that non-violent felons are still entitled to keep and bear arms. Let me start off by saying that Judge B, who wrote the opinion for the two justices on the three-judge panel, both himself, B, and Van Dyke, I think got the ultimate conclusion correct. I'm a little iffy about some of the legal reasoning. Most of it I actually completely agree with, but there is one central component that I do take issue with. Now, having said that, I don't think that it jeopardizes the decision at all, okay? That being said, it does require a little bit of introspection from a philosophical standpoint. The other judge, Judge Miller, interestingly enough, he's a dissenting judge in this opinion. And this also goes to show that just because a particular president might have nominated you to put you on the bench does not necessarily mean that we can predict your judicial outcome. All right, we'll talk about that as well. All right, so the bottom line in Duarte is that the Ninth Circuit, at least a three-judge panel within the Ninth Circuit, felt that Mr. Duarte, even though he is a felon, is still entitled to keep and bear arms in contradiction to 18 U.S.C. 922 G1, which makes it a federal crime for someone who is a felonious status to actually be in possession of that firearm. This three-judge panel essentially, at least within the context of the Ninth Circuit, invalidated that law as applied to Mr. Duarte. So the case, as I mentioned, is USA v. Duarte, aka Shorty. Apparently, this is his nom de guerre. And Mr. Duarte has somewhat of a colorful past. The fact pattern of the case is kind of unique. Well, maybe not particularly unique, but entertaining to say the least. So Mr. Duarte is accused and convicted of felonious vandalism at one point in the past. This negates his ability to be in possession of a firearm. Apparently, he subsequently picked up a secondary conviction as well. Anyways, on one particular night, Mr. Duarte and his friends are driving in a vehicle. Mr. Duarte's in the back seat. A responding police officer sees the vehicle driving by, notices that the windows are tinted, and decides to initiate a traffic stop. In the process, the driver of the vehicle decides to flee the scene, shall we say. And in the ensuing chase, officers witness Mr. Duarte throw a handgun out of the back window of the vehicle. Subsequently, the occupants of the vehicle are detained, and Mr. Duarte is charged with they find the gun, of course. He's charged with being a felon in possession of a firearm. He's convicted at trial, and then he appeals his conviction under a Bruin theory. The three-judge panel ultimately agrees with his argument. So let's talk about Judge B's analysis of this. Essentially, he says that the state makes the argument that Mr. Duarte is not entitled to be able to keep and bear arms pursuant to 18 U.S.C. 922 G1 because he is not part of the people. The people references law-abiding citizens. And since Mr. Duarte, while he is a citizen, is not law-abiding, as evidenced of the fact that he happens to have suffered a felony conviction before in the past, he is now stripped of his Second Amendment rights for the entirety of his life. And 18 U.S.C. 922 G1 is perfectly constitutional. Judge B and the secondary judge who also voted to overturn the conviction, Judge Van Dyke, disagree with the state's position. And in doing so, they go through a Bruin analysis. Now, if those of you watching this video are paying attention to the Supreme Court case that we are likely to get a ruling on here in the next couple of months at least, U.S. v. Rahimi, you might see some degree of a connection. Mr. Rahimi in the Supreme Court case is effectively, was charged with being in possession of a firearm, even though there was a civil restraining order preventing him from being in possession of a firearm. And the Circuit Court of Appeals, when they did their analysis on that one, found that to be unconstitutional. Like Mr. Rahimi, Mr. Duarte, they both sort of fall within this criminal status. And effectively, without going into all the legal reasoning associated with this case, Judge B says, no, you know what? At the time of the ratification, remember Bruin's core test. The first level of analysis is to determine whether or not the individual's Second Amendment rights have, in fact, been abrogated as a result of this statute. Well, in this particular case, Mr. Duarte is not allowed to possess a firearm, so by definition, his Second Amendment rights have been abrogated. Now the burden shifts to the state, and the state has to show how this law, in this case 18 U.S.C., is consistent with our nation's history, text, and firearms regulatory traditions that existed at the time of the ratification. Now, in this particular context, as in other cases, the state has argued we don't need to get to step two. All right, that in step one, we're able to essentially win our argument. The Second Amendment only applies to the people. And in this case, Mr. Duarte is not part of the people. So this case really focuses in on whether or not the individual that's challenging the law actually falls within the scope of protection of the Second Amendment. Sort of, who are the people? Now, if you were watching the confirmation of Justice Amy Coney Barrett at the Supreme Court, you might remember that there was a case that she was involved in when she was an appellate judge called Cantor v. Ohio. And in that case, she dissented. She felt that 18 U.S.C. 922 G1 was in fact unconstitutional. In that case, Mr. Cantor was convicted years ago of mail fraud. And as a result of that conviction, he was stripped for the entirety of his life of his Second Amendment rights. Well, he sued, claiming this was a violation of the Second Amendment. In that case, the appellate court agreed. However, Justice Barrett, she dissented. She said at the time of the ratification, there were not virtue tests to determine whether or not someone would be stripped of a specifically enumerated right. And in fact, as we go forward, we would look and we would say, is the individual that is being prohibited from bearing arms a dangerous felon? not a felon in general, but an actual dangerous felon. And one of the reasons for that is that the number of felonies that exist today are far greater than the number of felonies that existed at the time of the ratification. Back then, there were actually very few felonies that actually existed. In reality, if you were guilty of a felony, you probably were going to be put to death. That most felonies were capital crimes. Those that fell below capital offenses, those were usually regulated to misdemeanor status. Now, in our modern society, we've altered that pretty dramatically. There are a number of felonies that exist. And in fact, Judge B actually cites a Florida statute and says, in his opinion, if someone were to engage in a romantic gesture and send up a bunch of heart-shaped mylar balloons in Florida, he would be guilty of committing a felony and thereby stripped for the rest of his life in exercising his Second Amendment rights. This is clearly outside the scope of what our framers had intended. Now, I mentioned at the beginning of this video that I do take issue with a certain philosophical approach that Judge B, and by extension, Judge Van Dyke, used in determining who the Second Amendment actually applies to. In this opinion, both judges focus on who the people are, and they reference numerous times that the people are law-abiding citizens. This in and of itself becomes somewhat of a problematic analysis, because if civil rights only extend to citizens, then that effectively reasons that civil rights are somehow a manifestation of the government. If that is the case, then by definition, rights are transient. They can be taken away based on the political whims of the majority.
All right, so I just want to talk about that real quick. Do you think that a right should be taken away on the whim of the majority, as the guy from USCCA says? I mean, this is an interesting topic, and I just put this up because it is pretty interesting in my eyes, right? Having a legal background, having studied law for some years, I just think this is pretty interesting. I'm gonna see if I can find something else interesting for us to kind of dig in. Yeah, but leave a comment. Tell me what you think about that. You know, should people be able to keep their Second Amendment rights, or what? This guy's pretty cool. Big J Dre 357. Let's look at this here. Let's see what we got going on over here. Look like some dumb Negroes finna do some dumb shit.
Four suspects entered a store in Houston, Texas. Upon entering the store, all four males pulled out guns and pointed them at the store clerk while demanding the money from the cash register.
He got two bleaks.
While two of the males removed the money from the register, the other two took several boxes of cigarettes.
Yeah, they need to go to prison.
Once the suspects had the cigarettes and cash, they all fled the location in an unknown direction.
Yeah, the direction headed to prison.
Four suspects entered a store in Houston, Texas.
That's where they going. They going to prison. And that they should lose their gun rights. That's just kind of how this goes, man. Right? You commit some crimes and you go to prison, man. Where's that one? What's that one channel, y'all, where the guy is always showing up? He's always showing crimes like that. Let me see where this guy is. This is my guy. That's what we just was watching there. You guys watch this guy, Demcat? What y'all think about him, man? I think he's he kind of corny, man. He's not my cup of tea, man. Let me see. Where's these all right, hold on. I'm gonna click this because I know this is gonna lead me to the channel I'm looking for. That's a pretty cool channel too, man. Armed Attorneys, man. If y'all not hip to Armed Attorneys, man. Yeah, it don't look like I'm able to find what I'm looking for, man. He's cool too, man. I like this guy too, man. Yeah, but to win the silver, man, go over there and look at my other channel, man, the Bass Pro Shop, and see what you can see the 45 ACP bullets that I bought today. Tell me what they are.
At 17 Liberty 7, there are no words to come close to explaining how absurd it is that we have to walk on eggshells and pre-plan how to save our own lives from the scum of the earth with the least amount of legal ramifications. Yes.
I agree.
We are the Armed Attorneys. Back by popular demand, we are discussing again whether you should be shooting to wound or shooting to kill. And there are lots of different considerations to this. I mean, in addition to your basic safety considerations, we're going to talk about criminal law versus civil law. We're going to talk about whether or not you have a duty to render aid. And finally, we're going to be answering some of your questions from our previous video. But before we get started, show your support for the Second Amendment by hitting the like button.
And this is a very fun topic, and there's a lot of different paths we can go down. So make sure to stick around. But I think we have to start the discussion by talking about different levels of force that our law contemplates. So I'll say most states have 2 levels of force. Think punch, grab, tackle, restrain, maybe pepper spray, something that would hurt, leave a mark, but wouldn't cause serious bodily injury or death. Deadly force, that's force that's intended or causes serious bodily injury or death. Serious bodily injury would be like protracted loss of a limb, permanent disfigurement, loss of an organ, death. We all know what that is. And some states have a third intermediate standard because that's not clear enough, I guess. But we look at, all right, we have different levels of force. We're always seeing people on the news or maybe folks who don't understand how firearms work say, he should have shot him in the legs.
Mm-hmm. And unfortunately, what does that qualify as if you are shooting to wound, not shooting to kill? Richard, is that force or deadly force?
That's going to be deadly force.
So it doesn't help you in that regard, right?
No.
So in the criminal world, I mean, that's as criminal practitioners, we will tell you all day long that if you are going to shoot someone, make it count.
Sure. Well, I mean, the law, and this is the way that I imagine and talk to clients about it. Imagine it's one of these 2 buckets. Your use of force has to fit into one of the 2 buckets, or if you're in one of those weird states, you got your third middle bucket, right? But it's going to get filed into one of those categories. So anytime you discharge a firearm, it's going to fall in that use of deadly force bucket.
Yes. Now, I will say, looking at sort of the other side of things, and even as a criminal lawyer a little bit, you remember that one time I got to argue, well, he just shot him in the legs. And it was like actually great because it seemed really, really good. Like, oh, he didn't really want to hurt him. Now, I think that he probably just missed. But it was not a bad argument to make in court. But I will tell you from other lawyers' perspectives, i.e., my husband, who practices literally the other side of this, who does like wrongful death, and he's dealing with getting the money because you shot someone or because someone shot you. He will tell you all day long, shoot him in the legs, because scummy, horrible plaintiffs lawyers, if any of you are watching,
those are the people when you slip and fall at Walmart run up to you and give you a card. The ambulance chasers.
So they will take a dead body case 7 days a week, twice on Sunday. There are so many dollar signs attached to a dead body. However, you just get injured because you attacked somebody. I mean, there's still a scummy plaintiff's lawyer who will take that case, probably, but fewer and farther between, and they're probably worse lawyers and not going to get a good outcome.
Yeah,
So,
but on the other end of the spectrum, we just had a case where the person tried to sue for personal injury over someone brandishing a firearm in self-defense, and those plaintiffs' lawyers eventually, once everything came down to it, said, okay, they dismissed their own case. It's called a DWOP, dismiss without prosecution, for want of prosecution. So I mean, you see, they'll take a case like that, claiming personal injury. Can you only imagine what they do on the other end of the spectrum? But I think to answer that ultimate question, should you shoot to wound or kill? I think there's option 3, door number C, shoot to stop the threat.
Shoot to stop the threat.
Yeah.
Which is exactly what you should be saying in any official statement as well. Do my Lucille Bluth.
Don't do that.
No, because regardless, right? I mean, you can be like, this guy attacked me, broke into my home. I shot him to kill him as dead as I could possibly kill him. I still want you to say, I wasn't trying to kill him. I was trying to stop the threat. So it's always the right answer.
But don't do the wink. Don't do that. I actually had this sidebar, had a officer, I was a prosecutor at the time. I was directing his testimony, so I was asking him questions, fully cooperating, did everything he was supposed to do. The defense attorney asked him a simple question, and the officer immediately went, I don't recall. Looked at me. I was like what's up? Like, don't do that. So
I actually,
so...
without you telling me, I think I know what police agency he came from.
But all right.
Good old county that we worked in.
But to go on to so I think that answers the question. So it's going to be counted as a use of deadly force. Stop the threat. Obviously, most folks train shoot center mass. For that very reason. It's not practical otherwise. I mean, folks have trouble hitting the center of our target.
Right.
Especially in one of these dynamic situations. Can you imagine aiming for something so small? But I think the next question that came up a lot that we have to talk about is, do you have a duty to render aid should you find yourself in one of these scenarios? Let's say you aim center mass, you hit the leg, person's still alive. Are you legally required to help that person?
So, and that sort of we break out as well, right? Because generally speaking, and now I know people are going to chime in and say, oh, but I'm this or I'm that. And yes, there are some people who do have a duty under their licensure to go render aid, right? You are a EMT, things of that.
But even there, the scene has to be safe.
Right. So, yes, your particular circumstance, if you are one of those very special people, may vary, but generally out in the world, if you're just Richard or I, you do not have a legal duty. You're not going to get arrested or punished for not rendering aid. However, this is another place where the criminal and the civil lawyers may diverge a little bit, because the civil lawyers, again, who the civil guys probably want you to shoot the legs because you're less likely to get sued and less likely to pay out a bunch of money for it.
All right, so there it is there, man. I mean, the best thing to do is to not really aim at center mass, man, unless you're unless your life is really, really in danger, man. So here's the people I was talking about. Let's check out the latest video here, man. All right.
Welcome to the Active Self-Protection YouTube channel. My name is John Correa, and I am your host and an evidence-based defensive trainer. What we do here at Active Self-Protection Today, we're going to get a reminder that a seemingly minor attack can prove to be a serious problem. Hi, everyone. Welcome to today's lesson here at Active Self-Protection, where every day we post an analysis of a real-life defensive encounter so that you can make your training and your practice more evidence-based. I am your host, as always, John Correa. Today's video comes to us from Baoji City in China.
Download the Asp Unlimited app for all the content you love from active self-protection and more with no interference from YouTube. No ads, no age gates, exclusive videos, seminars, classes, and more on iOS, Android, Apple TV, Roku.
Look at the guys near the top on the left. They're having some kind of an argument. Now watch the guy in the white shirt with the brown pants walk away. And he's going to yip back at these guys a little bit. So the guys in black, they are going to take umbrage a little bit to what he says here as he's walking away. They're going to jaw at him a little bit. So then he is going to come back and jaw at them a little bit. And that's going to cause one of the guys in black there to come over. Watch what he does. And he's just going to stick him real kind of quick in his left thigh with a knife or some kind of sharp object. And if you look at what happened there, he caught his femoral artery. Now, if you're paying attention here, he is going to have 25 seconds of standing there while he's got his phone in his hand. I don't think he realizes how badly he's been injured here. And then eventually he is going to run out of blood volume while everyone else just kind of stands around, and he's going to fall there. Now, then watch these guys that, including the stabber, he just gets away, whatever. A bunch of people are walking around. They're going to move the table, but nobody's going to help him. Nobody's going to touch him. Eventually, somebody called emergency services, and they showed up eventually and did CPR on him. You're going to see pictures of it here in a minute, but it was way too late. And this guy passed away of his injuries. Nobody helped him. What a disaster. Straight up question. Are you carrying your first aid kit? Do you have a trauma medical first aid kit? Do you carry it? Is it with you all the time? I absolutely do. I've used it 5 times, and I hope you do as well.
Man, what y'all think about that, man? Dude just walked up, man, and just gushed him in the leg, man. And he just gushed out and died, man, and didn't nobody help the dude or nothing, man. That is crazy, man. Crazy, man. Dude just died, man. Tell me what you think about that. All right, so I think I'm finna start analyzing these videos, man. I like this type of stuff. So as y'all start to tune in on the channel, man, y'all will see that I'm fixing to start doing this, man. I like this, man, giving my opinion. Maybe y'all will like it, maybe y'all won't, man. This might be my new style of video, man. But we're going to always do precious metals giveaways, man. So be ready and be tuned for that. All right? With that, I'm going to say, man, y'all be blessed. I'm fixing to probably start another one.